For easements, I'll be doing this in a number of different lectures, so I'll do a number of recordings for easements. This is the first easement recording. When we look at easements, easements are a servitude, and a servitude is an interest in land which is an incorporeal hereditament, so it's intangible. And servitudes include property rights such as easements, profit-a-ponderers and restrictive covenants. For the purposes of property A, we'll be focusing on easements and restrictive covenants when it comes to servitudes. And we know from the topic of leases that a profit-a-ponderer is a license coupled with a grant. So we don't really focus on that in great detail, and our focus for today is going to be on easements. So, as I mentioned, servitudes are sometimes referred to as incorporeal hereditaments because they do not confer a right to possession. They are by nature non-possessory interests by which property rights might exist in another person's property. For example, a person with an easement has the right to use, or more rarely restrict the use of land in which another person has a freehold or leasehold interest in a particular way. Now, when we talk about restrictions, these are negative easements and they are not examinable. We focus on positive easements. Okay? So in terms of a definition of easements, an easement is a right enjoyed by the owner of one piece of land called the dominant tenement, the exercise of which interferes with the use and occupation of another piece of land, the servient tenement. Let's go through and understand the terminology. So as I mentioned, our focus for property A is on positive easements, which gives the holder of an easement the right to do a certain act on somebody else's land. For example, a right to passage. And the most common one is a right of way, which we'll be looking at the relevant cases. There are negative easements, but we don't focus on that. If we look in terms of negative restrictions, our focus is going to be on restrictive covenants when we look at that at the next topic. But I really want you to understand is the difference between the dominant tenement and the servient tenement. And I'll often refer to these as the DT and the ST. So the DT is the land, so to speak, that's getting the benefit of the easement. Okay, so if there's a right of way, the DT is the land who's getting the benefit of using that other land to cross over perhaps and get to the beach or get to a road. Whilst the servient tenement is the parcel of land burdened by an easement, usually for the benefit of the DT. So in that respect, if there's a right of way to access a road or a beach or a path, it's the land which the person's crossing over to do so, which is the servient tenement. So when you want to think of an easy way to remember the difference between a DT and an ST, think of the ST as being the one who's serving, okay, who's being burdened, whilst the DT is the one that is being benefited as a result of the easement. This is a really good diagram to understand the difference between a DT and an ST to see how easements operate. If we look at lot A here in the diagram, lot A is the DT. It's being benefited. Why is it the DT? Because as you can see here, there is a line going across A into B, which is allowing A to access the road through B's property. Therefore, B, the servient tenement here, is being burdened. So A is getting the benefit, B is the burdened land, and the owners of A are allowed to use the easement to cross through B to access the road. This is an example of a right of way. So as I've written here, this is an easement, in this case a right of way across lot B to access the road. So in every easement that we're going to be looking at, we need both a DT and an ST. So we need to first identify what land is the DT and what land is the ST. And by that, we can start to form our answer in terms of what is an easement in the question, and how we go about working out if there is a valid easement. There are a number of elements that we need to satisfy to form a valid easement. We'll be looking at those elements of an easement in a moment. We'll then move on to looking at the scope of that easement. So that's looking at how far can we take this easement? What else can we do? What is it limited to? And we also need to show that the easement's been validly created. Okay, so that's when we look at creation of easements. So we'll take it one step at a time. So the first step is to work out, have the elements of an easement been satisfied? And these elements have been set out in cases like Ellenborough Park and also in Riley. I'll go through the four of them just now briefly. We'll then look at the cases, and then we'll come back to going through these elements to see how the cases have worked through each requirement. So the first requirement is there must be a DT and an ST. So we need to identify what land is the DT and what land is the ST. That's step one, and that shouldn't take you too long to work out. It's just identifying the different land parcels in question. The second requirement is the easement must be for the benefit of and must accommodate the DT. So in that respect, we're looking at accommodating the land itself and the benefit of the land itself, opposed to any personal rights of the owners. We'll look at the cases in a moment to see what that means. The third requirement is that the DT and the ST must not be owned and occupied by the same person, because you can't have an easement over your own property. And the fourth requirement is the easement must be capable of forming the subject matter of the grant. And there are a number of things which we'll later consider when we're working out whether or not the easement is capable of forming the subject matter of the grant. So for now, I want you to remember that there are four elements when we're trying to work out if there is a valid easement. And let's now go look at the cases that discuss these issues. We'll go through the cases in detail, and then we'll come back to these 4 points to nut it out, to work out what part of the case we need to include for each of these requirements when we're setting out our notes. The first case that we'll be looking at is the case of Ellenborough Park. And I'll go through the facts now. D and W owned land which they subdivided, and the inner portion was known as Ellenborough Park. In each conveyance for the surrounding lots, purchasers were granted the full enjoyment whom such easements may be granted of Ellenborough Park, but subject to the payment of fair and just proportion of the costs, charges, and expenses of keeping in good order and condition the said pleasure ground. I've got that quote up here on the PowerPoint slide. So the vendors covenanted with the purchaser and successors to retain Ellenborough Park as an ornamental pleasure ground. I've got a little picture which I'll put up in a second. So here we go. So we can see here Ellenborough Park is quite a large park, and all the lots surrounded that park. So the park was in the middle and all the lots surrounded it. So it was a little community. So the issue was, did the purchasers, the subsequent purchasers that is, have the benefit of the easement over the park? And the reason why I say subsequent purchasers is we know that if it was just a personal interaction between the original covenantee and covenantor, they would be bound by contract. But we know that those who are not privy to the contract are not bound by that. Therefore, if it was a property right, it's enforceable in rem, therefore enforceable against the whole world. So the court had to look to whether there was a valid easement or not. So did the landowners, did those lot owners surrounding the park have an easement to use and enjoy the park? And the court stated that there were 4 elements that needed to be satisfied if this was a valid easement. And I mentioned them before when we look at that original slide here, 1 to 4. The court stated that, as I mentioned, there were 4 elements, but here characteristics 1 and 3 weren't an issue. Yes, there was a DT and an ST, and no, they weren't owned by the same person. They were owned by different people. So characteristics 1 and 3 were not an issue. At first instance, the easement was found. The court found that the easement accommodated the DT. The easement benefited the amenity and the value of the DT. In terms of the rights capable of forming the subject matter of the grant, the court held that this was not a mere right of recreation. They defined full enjoyment as the right to walk around the park, to sit down, and to picnic. This case went on appeal, and on appeal an easement was also found. On appeal, the court found that the easement accommodated the DT in relation to the defined rights of full enjoyment. Let's get back to that quote there. And this is a question of fact in terms of working out whether or not it defined the rights of full enjoyment. The court found that the DTs were residential lots, and so Ellenborough Park benefited them in a real and intelligible sense as a garden. The easement improved the value of the surrounding lots in a way that was connected to the normal enjoyment of the DT. This was because the DTs were residential houses of varying sizes, so that the park constituted the garden of those surrounding houses, as I mentioned, in a real and intelligible sense. In terms of working out whether the right was capable of forming the subject matter of the grant, the court held that, number one, it was not too wide or vague. Secondly, it was not inconsistent with the ST's rights of ownership and possession. And thirdly, it conferred utility and benefit to the DT. The court held that the right conferred by the grant was not a mere right of recreation, in the sense that it's a personal right, so it wasn't a license. So it was not a mere right of recreation in the sense that it was a personal right to wander at will over all and every part of another's land. The rights in the grant provided a limited number of houses with the use of a single private garden, therefore conferred utility and benefit to the DT. So we can see from this case here that it's established for us the requirements of what we need to satisfy for an easement. And we'll come back and nut it out in terms of where we put each bit of the facts of this case into these elements. But as I mentioned, elements number 1 and 3 weren't an issue. 2 and 4 were the elements which needed to be discussed in more detail, and the court in fact found for a valid easement. Okay, so those are the basic facts, and have a read through the judgment as well at your own time, and you'll be able to also pull out some more information. I'd like to now go to the case of Riley and Pentala. And in this case, there were subdivided blocks, and in each transfer, there was granted the liberty to use and enjoy the reserve as a park or garden. So this is the case of Riley and Pentala, R-I-L-E-Y and P-E-N-T-T-I-L-A. So in 1971, the defendants bought lot 36 and started excavating land as a swimming pool. And the question before the court was whether the neighbours could object on the grounds that they'd been granted an easement back at the time of subdivision. The defendants argued that the right to use and enjoy the park was too vague and uncertain to satisfy the fourth requirement. And in this case, Justice Gillard found that all 4 characteristics were present in the transfer. So this case of Riley and Pentala, which I've got up here, 1974, affirmed the case of Ellenborough Park and found that the 4 elements of an easement existed. As I said, we'll come back to these cases in a moment. The next case I'd like to go through is Copeland. And I've got the facts up here. Copeland owned land and used it as an orchard, with the adjoining houses, as well as a strip of land that was used to access the orchard from the North Street. Greenhalgh owned a house and workshop on the land opposite to the strip, and the question was whether Greenhalgh, who'd used the strip to park the cars that were waiting for collection or repair, whether he had an easement over that land. So just to make it clear, we had Copeland, who owned land, and Greenhalgh, who owned a workshop across the road from this land, had parked his cars there because he was a mechanic, and he parked the cars when they were fixed and waiting to be collected. So the issue was this in fact an easement? Did Greenhalgh have an easement over this strip of land? So namely, were the rights capable of forming the subject matter of a grant? Were they too wide or vague, or inconsistent with seized rights? The court held that Greenhalgh did not have an easement. The rights benefited Greenhalgh's business and not the land. Therefore, it was a personal benefit and not benefiting the DT itself. Furthermore, the rights amounted to joint use of the land, and joint occupation is not permitted when we're looking at easements because it is substantially depriving the ST of their rights. So we're now looking at the case of Closs Farming, and the facts are as follows. Closs Farming operated a vineyard on lot 86 of a development. Residential lots surrounded the vineyard, such as lot 27, owned by Easton. Pursuant to an easement for vineyard, Closs purported to have rights to enter the residential lots, to carry out viticulture works, harvest grapes, and sell them. Closs could deduct its cost from the sale price paid to Easton under the commercial agreement. Closs lodged a caveat in respect of these agreements, and a dispute arose whether these rights were caveatable. So a caveat is something that you lodge to try and show that you've got an interest in land, and to notice to all on the register that there is an interest, this being perhaps an easement in this case. So the question was there a valid easement? At first instance and appeal, it was held that this was an easement to vineyard, and it was not an interest in land, therefore not caveatable. So therefore this was not a valid easement. Why? Did the easement actually accommodate the DT? No. There was no real connection between the DT, lot 86, and the ST, lot 27. Here, the court held that commercial necessity is insufficient. So did the easement accommodate the DT? No. Accommodation is the natural connection between the ST and the DT. A right reasonably necessary for the enjoyment of the DT, and not merely confer advantage on the owner of that tenement, as it was a mere contractual right. As a question of fact, it was found that the use of the land was convenient and nothing more. The connection was not a real one. The rights were connected to the conduct of the trade on the land, and therefore independent to the normal enjoyment of the land itself. Lot 27 in dispute was one of many lots that could have been put to this use. Commercial necessity regarding the DT was not enough to save it. In relation to the last element, capable of forming the subject matter of the grant, the court held that this was not satisfied. The rights were inconsistent with the ST's rights as owner, as the ST could do very little with the burdened land. So in terms of looking at whether this right was capable of forming the subject matter of the grant, by reference to the 3 subsections, which we'll look at in a moment, the court held no. It would amount to joint occupation or deprive the ST of their legal possession. And at trial it was found that these rights were inconsistent with the ST's possession, as only recreational rights were left for the ST, as so many were reserved for the DT. On appeal, it was suggested that these rights were reasonable based on the land being rural farming land. However, this was not accepted. The rights were inconsistent as the ST could do very little with the burdened land. They were left with a mere shadow of rights. So just to confirm, the issue here was whether the purported easement for vineyard accommodated Lot 86, the purported DT. And as I mentioned, the easement claim failed. Justice Bryson concluded that the restriction was not a valid easement, and the New South Wales Court of Appeal upheld this decision. Elements 1 and 3 were not an issue, but in terms of element 2, the DT was merely used for storage. It was merely a convenience, and thus no evidence of accommodation, advantage, or enhancement of Lot 86. It rejected the argument that if not physically serving on another, they were economically tied. In relation to the 4th requirement, the court was concerned that these rights were too wide, that they deprived the ST of possession, and the ST had minimum control over their own land. The DT, as a result of this agreement, had a plethora of rights over the property, and they were left with the mere shadow of ownership. If we look at paragraph 13 of the judgment, it says that free for every person in whose favour this easement is created, and every person authorised by him either with or without vehicles, farming implements and machinery, to enter, go, pass, repass, turn around, and remain upon that part of the lot marked B on the plan for the purpose of carrying the vineyard, establishment works, the planting and replanting of grapevines and crops, the planting and harvesting of crops, spraying, slashing, vineyard and crop maintenance, and the harvesting of grapes and crops together with the right from time to time to sell the produce of such harvest, and to deduct therefrom and retain the cost of farm maintenance, harvesting, packaging, freight, agent's commission, marking and reasonable administration costs associated with such harvesting and the sale of such harvest. So the court considered whether or not this was a valid easement, and both the Supreme Court and the Court of Appeal found that there was no valid easement based on these rights in issue. Therefore, no caveat could be lodged, and if a caveat was lodged, it would have to be removed. So you can see here that I've summarised the facts on this slide. That Closs Farming operated a vineyard on Lot 86 of the development. We know the residential lots surround the vineyard. We know that both at first instance and appeal, no easement was found. We need to look at elements 2 and 4 when we're looking at this case, because 1 and 3 were not an issue. And by looking at the judgments of both first instance and appeal, the court was not willing to accept that a valid easement was created on the facts. So we get now back to those elements 1 to 4. And now that we've gone through the facts of the cases, I think it's important now to use those facts and to put it into the element so we understand how it applies. So to recap, the first element is there must be a DT and an ST. Okay? So we need to apply that to the facts. So on the facts, we say this land is the DT, and on the facts, that land is the ST. Remember, we're referring it to the land and not to the personal rights of the owners. So we don't say, we use the description of not saying it's John. This is John's right, but rather the land belonging to John, because it's a right in relation to rem, and not personal rights. So when we're going through an exam question, for example, and we've identified the DT, and let's say the DT is owned by John, we might say the DT is the land that's owned by John. So we're identifying the land itself. So identify what land is the DT and what land is the ST. Why is it the DT? This is because it's the parcel of land that enjoys the benefit of the easement. And why is this land the ST? This is because the ST, who is on the facts, whoever they are, can be defined as a land which is subject to the burden of the easement. So as I mentioned, elements 1 and 3 don't often cause that many issues. It's elements 2 and 4. So they're the ones that we're going to be focusing on. So as I mentioned, the second element is the easement must be for the benefit of and must accommodate the DT. Okay, what does that mean? It means there must be a connection between the alleged easement and the DT, in the sense that the DT benefits from the easement. And we can have a look at Bradbrook in terms of what they have to say about easements in paragraph 17.50. So an easement must benefit the DT, therefore making it a better and more convenient property, and not benefiting the personal rights of the DT. So let's have a look at how the cases have dealt with this. So when we're looking at this element, the easement must be for the benefit and must accommodate the DT. We're talking about the land. Is this making the land more convenient? So thinking about if we were trying to get access to a beach, if it's in that area and that's allowing the property to have access to the beach, that is accommodating the DT. It is for the benefit of the DT. Yes, the owners of the DT are getting a benefit from it, but anyone who's using that property and has rights to that property is going to get that benefit. Okay, so it's not merely personal. So let's look at how the cases have dealt with this. So remember, in Ellenborough Park, it was held that the recreational use of the park benefited the DT, and the test was satisfied as the use of the garden undoubtedly enhanced and was connected to the normal enjoyment of the house to which it belongs. Okay, so you can see here that in terms of Ellenborough Park, it enhanced the property by allowing there to be some sort of pleasure grounds, having garden, having greenery, because some of the houses didn't have big gardens, some of them had different sized gardens, but it was benefiting, it was accommodating the DT. We know from the case of Copeland, when such a right accommodates a business conducted on the land, an easement may be created. But in Copeland, no such easement was created because it amounted to joint occupation, which is something which we need to consider in element 4. But thinking about that commercial side of things in terms of, is it benefiting the DT or the ST? We know from close farming that we need to show a connection with the land and better enjoyment of the land, not just a commercial advantage on business. So it's not enough for the ST to be a convenient incident to the right. There must be a nexus between the DT and the ST, and it must be real and intelligible. So that's from close farming. And we know from close farming the easement did not accommodate the DT, as there was no real and intelligible connection between the easement rights and the ordinary use of the DT or any advantage or enhancement. So it's not saying, I'm not trying to say that that it can never benefit the land commercially, but in these cases of Copeland and Greenhalgh, mainly because of elements 4 as well, in terms of like just leaving them with a mere shadow of rights and joint occupation of the property, which is not allowed when it comes to easements. Here it was really just benefiting the commercial side of things opposed to the land itself. So there will be circumstances and times where it's benefiting both the commercial side of things, the business itself, and the land. But there's just a fine line in terms of how far that's going. So it's a judgment call you need to make when you're going through the question. We'll come back and address that when we get back to element 4 in a moment. So as I mentioned again, elements 1 and 3 aren't really the issues that often crop up as being huge things when it comes to easements. It's not our main focus, but we do need to go through it. And as I mentioned, element 3 is the DT and the ST must not be owned and occupied by the same person. And this proposition is based on the rationale that the one person cannot acquire rights against herself or himself. It doesn't make sense. So a person can't have an easement over their own land because the very nature of an easement connotes rights which are exercisable against the land of another. and this presumption is based on the rationale that no one can acquire rights against themselves. So it's just a common sense approach. So that's elements 1 and 3. We've covered 2, and 4 is probably our biggest one that we need to consider and look at. So you can see here I've put asterisks next to some of the cases. That's because I've got slides which follow, which are referenced those asterisks. So we'll go through them. So the first thing we need to ask ourselves when it comes to the easement being capable of forming the subject matter of the grant is, are the rights expressed too vague, or are they too wide? Because if they're too wide or vague, they're not going to form the subject matter of the grant. We need to know what are those rights. Okay, we need to identify what is the easement in question. The second thing is the right must not amount to a right of joint occupation or substantially deprive the owner of the ST of possession and enjoyment of the land. Okay, what do I mean by that? We can see that from Copeland and Closs farming. So you can see here that we've got 2 asterisks. So if we just go to the 2 asterisk slide, we know Justice Santo in Closs farming held that the easement was deemed to have subordinated the rights of ownership of the servient tenement owner, such that there were a shadow of the entitlements normally associated with ownership, and the servient owner's rights were so attenuated as to no longer meet the description of exclusive possession. And this is from the judgment from 49 to 50, if you want to go have a look at it. So we're looking here in terms of joint occupation. What does that mean? The idea is that you've essentially left the ST with a shadow of rights. You've deprived them of use of their land. Now that's not allowed when it comes to an easement, okay? It's unlike a lease where you have exclusive possession. With an easement, you don't have exclusive possession, okay? You've got a right to pass, for example, or you've got a right to do something on the land, but it can't be something where you just sit there and don't move, or you're there and you don't allow the ST to use the land as they intended, okay? We have to be very clear on that. And again in Copeland, remember the case where it came to the car, leaving the cars on the other side in that strip of land where he'd park his cars once he finished working on them. And in this case, Lord Upjohn said the following: I think that the right claim goes wholly outside any normal idea of an easement. That is, the right of the owner or the occupier of a DT over his ST. This claim, to which no closely related authority has been referred to me, really amounts to a claim of a joint user of the land by the defendant. Practically, the defendant is claiming the whole beneficial user of the strip of land on the southeast side of the track here. He can leave as many or as few lorries there as he likes, for as long as he likes. He may enter on it by himself, his servants and agents, to repair work thereon. In my judgment, that is not a claim which can be established as an easement. It is virtually a claim to possession of the servient tenement, if necessary to the exclusion of the owner, or, at any rate, to a joint user, and no authority has been cited to me which would justify the conclusion that a right of his wide and undefined nature can be the proper subject matter of an easement. So we can get from this case here that any right which is alleged to be an easement, if it's taking away the rights from the ST, it's not forming the subject matter of the grant. Okay, so the right, if we look at B here, the right must not amount to a right of joint occupation or substantially deprive the owner of the ST. If we're looking at that sort of instance, then we have to question, maybe is it a license? Is it a lease? What could it be? But it can't be an easement, okay? If you're literally putting a car on the property and not moving it, it cannot be an easement. In Closs farming, if you're going there and performing viticulture works and taking produce, selling produce, and leaving the true owner, the ST, with a mere shadow of ownership, this cannot form the subject matter of an easement, okay? Let's be very clear on that. And the last requirement is whether the rights constitute a mere right of recreation, possessing no quality of utility or benefit. So in this example here, Ellenborough Park, our case example, remember, there was a central park around a whole lot of lots, and these lots use this park to picnic, to play games, to play sport, to walk, it was to wander essentially and enjoy. And the easement accommodated the DT in relation to these defined grants of full enjoyment because, as I mentioned earlier, the DTs were residential lots, and so Ellenborough Park benefited them in a real and intelligible sense as a garden. Let's turn to the judgment. So we see here that it's got 3 asterisks. We'll just Go to the slide with 3 asterisks. So this is Lord Evershed that gave this judgment here. And I know it's very kind of representative of the time. It's an older case, but I think this really sums up what we're looking at in terms of a mere right of recreation. So the court is quite liberal in this approach. So wandering a garden is actually not a mere right of recreation, with no utility. So if we read this judgment, it says, this paragraph in the judgment says, no doubt a garden is a pleasure. On high authority, it's the purest of pleasures. But in our judgment, it is not a right having no quality either of utility or benefit, as those words should be understood. The right here in suit is, for reasons already given, one abhorrent to the surrounding houses and, as such, and constitutes a beneficial attribute of residence in a house as ordinarily understood. Its use for the purposes not only of exercise and rest, but also for such normal domestic purposes as were suggested in argument. For example, for taking out small children in prams or otherwise, it's not fairly to be described as one of mere recreation or amusement, and it's clearly beneficial to the premises to which it's attached. So I think the key thing here to understand is when we're looking at a mere right of recreation, it can be a recreational right, but it has to be one that possesses utility and benefit. If it's allowing someone to go and play PlayStation or watch Foxtel, that might be a right of recreation possessing no quality of utility or benefit. So we need to really compare and contrast this case to any cases that we get that might be merely recreational and work out, is it actually providing quality and benefit to the DT, the land of the DT? And if so, just like in Ellenborough Park and just like in Riley, it will be the subject matter of the grant. It will be valid. But if it's different, if it's watching Foxtel, watching a movie, playing PlayStation, something like that, that might be a right of recreation possessing no quality of utility or benefit. So just to recap now, back to this slide here, there are 4 elements that an easement needs to satisfy in order for it to be valid. Let's go back here. Sorry. There must be a DT and an ST. The easement must be for the benefit of and must accommodate the dominant tenement. The dominant and servient tenements must not be owned and occupied by the same persons. And the easement must be capable of forming the subject matter of the grant. As I mentioned, elements 1 and 3 often aren't in issue, but you need to, for the purpose of the exam, state for element 1 who the DT and the ST is, state that they may not be, that they're owned by separate people, and the main focus is on elements 2 and 4. And in my slides, as I've gone through it, as you can see here in relation to elements 2, refer back to the cases in terms of accommodating and benefiting the DT. Work out why, ask yourself, why in Ellenborough Park was it accommodating and benefiting the DT? Why in Copeland was it not? Why in Closs Farming was it not? Okay? And understand sometimes it can benefit the business or the commercial needs of the land. But if that's all it's benefiting, then that's not going to be enough. And with element 4, the easement being capable of forming the subject matter of the grant, working through those 3 points, okay? Are the rights expressed too wide or vague? Is it amounting to a right of joint occupation? Is it a right that merely constitutes a mere right of recreation, possessing no quality of utility or benefit? And if you can't satisfy even one of these, it fails. All 3 need to be satisfied. So they're the 4 requirements for an easement. But we don't just stop there. We need to also focus on scope. And Sackville and Neve note on page 975 that in practice, the most frequent issues arising in relation to easements are whether the acts of the owner of the DT are authorised by the terms of the easement in question, and whether the acts of the serving owner constitute an interference with those rights. And we'll look at in a second in relation to a case, Westfield, that demonstrates some of those issues. So scope is essentially saying we agree in the agreement that yes, there's an easement, but how far can that easement go? So if you've got an easement to cross land to get to the beach, get to the park, or use a park, how far can we take that? So we're looking at really that inner circle of, yes, there is an easement, but what sits inside the easement, those rights that you can use and enjoy inside that easement fit within the scope, and anything outside that circle is outside the scope. So what is the scope? The scope is essentially the bounds, the measures in which you can use the easement freely, but anything beyond that will be in breach of the easement, okay? And this is often an issue which the courts have to deal with and grapple with. So the case in question here is Westfield Management and Perpetual Trustee Company. It's a 2007 High Court case, okay? And it deals with a registered easement. So this is a registered easement. So an easement here was registered and put on title. And the High Court in this case had to construe the terms of the easement to determine its scope, to understand, well, what did it mean essentially? And because it was a registered easement, we actually had the instrument on title, okay, and we could actually see what it was, okay? And the words in relation to this registered easement said, to and from a certain building. You could pass to and from a certain building. So here is these are the buildings in question, the land in question. We have Glass House, Sky Garden, Centre Point, and Imperial Arcade. Okay. So in this case, we're dealing with land in Sydney, and if those of you who are familiar with Sydney CBD, we have the Pitt Street Mall there at the bottom, and we have King Street. And you might be familiar that Pitt Street Mall is just like our Bourke Street Mall, and there are no cars. There's no vehicle access allowed in Pitt Street Mall. Therefore, in order to enter some of these buildings, we'd have to rely on King Street. Now, Glass House is owned by Perpetual. Sky Garden, Centre Point, and Imperial Arcade is owned by Westfield. And originally, there wasn't a valid easement, a registered easement between Glass House and Sky Garden. In fact, it was actually created before Perpetual and Westfield even owned the properties. So from earlier landowners, okay? So they weren't the original parties in agreement with this easement. Again, a demonstration of the power of in rem, that it's enforceable against the whole world and it passes with the land to each landowner. So originally, Westfield only owned Sky Garden, and the easement allowed Westfield customers to enter King Street, to go underground, cross through Glass House and park in Sky Garden. So if we look at the terms of the easement, I've just got them here. It's to go, pass and repass at all times and for all purposes to and from Sky Garden. So if we're thinking about it, and I'm just going to get my mouse out to demonstrate. So if they come down King Street, they're going to go under Glass House, cross over here and get to Sky Garden. So looking at the terms of the easement, to go, pass and then repass, just the in and out. So the question was, what did this mean? And why do we need to know what this meant? Because Westfield then buys Centre Point and Imperial Arcade. And they want their customers to go into King Street, go through Glass House, go through Sky Garden, and possibly park under Centre Point and Imperial Arcade. So to use that entry, that easement, to get to Sky Garden, but then to go further. So the question before the court was to go and pass and repass at all times and for all purposes to and from Sky Garden. Did that mean they could go to Centre Point and Imperial Arcade as well? Well, that's what the court had to consider. And in a unanimous judgment, the High Court dismissed Westfield's appeal. So it got up to the High Court, and the High Court said that this right of carriageway easement, so the right that allowed those people that wanted to go to Sky Garden, the right to go, pass and repass at all times and for all purposes to go to and from Sky Garden, so from Glass House into Sky Garden. On these facts, this easement allowed those users of Sky Garden to park in Sky Garden through entry through Glass House, but not any further. But it did not extend to allowing persons wanting to gain access to the land adjacent to the DT. So that land being Centre Point and Imperial Arcade. In terms of looking at the wording here, to go, pass and repass at all times and for all purposes, I mean, focus on that word all purposes. And it is quite extensive in terms of what all purposes means. But the court considered and concluded that there must be some sort of limit as to what all purposes means. And in doing so, the High Court found that the trial judge should not have looked outside the terms of the grant for extrinsic material to determine the intention or contemplation of the parties regarding the scope of those rights. But instead, because this is torrent system, because this is on register, we can't expect third parties to go and look to see what other things were agreed upon. We need to look at these terms to go, pass and repass at all times and for all purposes to and from Sky Garden, and actually try and construe what they mean. And the High Court found that this clause here, to go and to pass and repass, was in fact limited to going through Glasshouse to access Sky Garden, but not any further. So they couldn't then cross over to Centre Point and Imperial Arcade. I'm guessing it's going to be quite hard to police who's actually coming in here and parking here, and then who's going across and across. And despite the fact that this case was, Westfield lost this case, I'm sure they would have agreed to something anyway, because those of you who are aware, Westfield Sydney CBD has been built since, and there is car parking, so they may have come to their own private agreement or arrangement as to how access into King Street could be achieved. But in terms of property law and easements, what the High Court tells us is they could access Sky Garden, go under Sky Garden to access, go through Glasshouse to access Sky Garden, but the easement only allowed that and nothing more. Anything else would be in breach of the easement and in breach of the scope, and therefore would be actionable. So what we get from this case is there was a valid easement, a registered easement. When it comes to registered easements, we need to look at what the terms are saying. We can't go to extrinsic material or material from third parties, because that would be inconsistent with the torrent system, because remember, the principle of the torrent system and the concept of registration is what you see is what you get. Okay, you don't have to look into other documentation to find out what rights this interest confers. And by looking at this clause here, the court ultimately held that this was limited, the easement was limited to entering Glasshouse to get to Sky Garden, but not going further, just to go in and out. As I mentioned, Westfield may have agreed with Perpetual on other terms in terms of entering Glasshouse for other purposes, but that would not be subject of an easement, but perhaps a license, or perhaps they would have extended their easement. But that would be a private discussion that those two parties would have to have. And in terms of this easement in question, it had nothing to do with it. The only thing this easement allowed was entry to get to Sky Garden, park underneath, and then out. So Westfield is our case on registered easements in terms of scope and the parameters. And the next case of Cargill and Gotts considered the frequency of use of an easement. In Cargill and Gotts, Cargill owned a farm and drew water from a pool in a nearby river for his stock. Cargill took more water in later years, which he used to spray crops. Gotts eventually became the owner of the land surrounding the river and took action to prevent Cargill from using it. Cargill sought a declaration that he had an enforceable easement to abstract water for the purposes of his farm. The court found that Cargill had the benefit of an easement to take water. The abstraction of water after 1965 was in fact illegal without a license. But if Cargill could establish that he had an easement before then, he could continue to take the water. So let's understand how much water was being taken. So if I go through the facts of the case, in the early days, before 1927, the water access was by way of cart for use on the farm, and mainly for watering horse and cattle. The water cart carried a barrel with a capacity of between 50 to about 100 gallons of water. The water cart drew water from the ponds, that pool, at intervals of time which varied according to the season, and witness evidence anywhere from 4 times a week to 2 to 3 times a day. As I mentioned, in about 1942, Cargill began to use the water from Mill Pond to spray crop on the Grove farm, and at this time the water cut was replaced by a tank which held about 250 to 300 gallons, so it increased considerably. Crop spraying was originally carried out in April and May, but was progressively extended and intensified. From the 1950s onwards, the quantity of water the plaintiff took from the pond increased tenfold, and the plaintiff used it to spray crop as well as to water the cattle, and the 25-gallon tanker was replaced by a tanker called a Bowser, Bowser, and there was a second tanker used as well, so that 1,400 gallons could be drawn from the mill pond, that pool I was talking about, by means of a pump attached to the Bowser. And occasionally Cargill drew up to 4,000 gallons in a single day. So as I mentioned, when Gotts bought the farm that owns the mill pond in 1977, he actually tried to stop Cargill from accessing the pond. And it was held that Cargill was entitled to a declaration that he had an easement at common law to draw water from the pond, and an injunction stopping Gotts from interfering with that right was granted, plus £50 for damages, remembering this is in 1977, for interference with this right. So if we look at page 686 of the judgment, Lord Templeman says, "In my judgment, it is a mistake to concentrate on gallonage, Gallonage, as a detailed user. When Grove Farm, in or before 1927, took 100 gallons for a mill pond to water 100 bullocks, Grove Farm did not begin to acquire an easement to take 100 gallons to water 100 bullocks, but began to assert a right, which after 20 years ripened into an easement, to take water from mill pond for the benefit of Grove Farm for all purposes, according to the ordinary and reasonable use to which Grove Farm might be applied at the time when the right was and continued to be asserted." So what does that mean? This means, well, with reference to the 20 years, we're going to look in our next online lecture about how an easement can be created, and one such way is long user, and that's a period over 20 years. But for our purposes in looking at this in terms of scope, what the judgment is essentially saying here is that there was the scope of the easement wasn't taking 100 gallons, but rather taking the right was just to draw water, no matter what that water, no matter how much water, as long as it was for the purpose of using it for the farm. So the court is basically saying that looking at whether taking water was relevant to the ordinary and reasonable use to which the farm was applied at the time when the right was continued to be asserted was relevant. And the farm had always been a farm, and in general, although the exact animals and the use to which the water was put over time had changed, the water had always been taken for farming purposes. Okay? So we're looking at here about that there was an easement to extract water for farming purposes. Now this is a little bit different to Westfield. Why is it different? Because this is not a registered easement. Okay? So it's different. So if this was a registered easement, we would be looking at the terms of that registered instrument. We don't have that here. Okay? So there's a little bit more room to move in that sense because there's nothing documented as such. But by looking at the frequency of use and looking at how the parties, the plaintiff in this case, in terms of how Cargill used this easement, so to speak, the easement, according to the court, was one to draw water for all farming purposes, no matter if it was 20 gallons, 200 gallons, or 2,000 gallons. So to summarise this case, a farmer had acquired an easement by long use to take water from a mill pond on his neighbour's land, and the court held the easement did not relate to a specific volume of water, so the usage could vary from time to time for all farming purposes. So to recap what we've covered today in today's online lecture, we have looked at the elements of an easement. Okay, there are 4 requirements. We need to satisfy each of them. We need to use the cases that we've covered in relation to a specific set of facts to make reference, to distinguish, to point out the similarities as to why there may or may not be a valid easement on the facts. We might also get a question that doesn't also just deal with validity of an easement. We might be told there's a valid easement, but there might be a question that deals with scope. And the 2 cases that I want you to consider when dealing with issues of scope, so the parameters in which how far that easement can extend, is Westfield and Cargill and Gotts. So as I mentioned, Westfield deals with registered easements, Cargill and Gotts non-registered easements. Okay. The next online lecture will deal with creation of easements, but it's really important to note that even if you have a valid easement in terms of those 4 requirements being satisfied, if it hasn't been created validly, it's going to be invalid. So we need to not only show and prove those 4 requirements of an easement, we also need to show that it's been created validly. And that's what we'll be focusing on our next online lecture. Thank you.